first person, we're going to have David E. Mastagni, who will be joining us virtually. Mr. Mastagni, are you with us?
Yes.
Thank you very much for being with us, and you may proceed when ready. And you have 6 to 8 minutes.
Good afternoon, and thank you for the opportunity to appear. My name is David Mastagni. My practice focuses on representing public employees and their unions. My law enforcement clients understand the continuing need for police reform, particularly at this moment in our nation's history. Accordingly, we have worked tirelessly with stakeholders and the leadership to modernize use of force standards, establish statewide use of force policy requirements and training, and increase transparency. I've been asked to, and I will, explain the disciplinary process and the due process rights afforded all public employees in California. My time is short, but I also want to be clear that my clients support a licensing revocation process to assist in striking the proper balance that addresses legitimate and shared concerns over bad officers avoiding accountability while maintaining fundamental principles of due process and fairness for innocent officers. With respect to the disciplinary process, it's first important to remember that officers are subjected to greater scrutiny and held to a higher standard than other public employees in California. The Penal Code mandates that every agency establish and publicize a process for accepting complaints of misconduct against officers, and also mandates the investigation of those complaints. That's not true in every state. The process commences when a complaint of misconduct is received. Importantly, investigations are not limited to complaints by members of the public. And in fact, my experience has been that a majority of the internal affairs investigation are generated by complaints from supervisors or managers. The agency then begins interviewing witnesses and investigating the case in a manner similar to a criminal investigation. The accused officer is interrogated last. The accused is not notified of the investigation typically until a few days before his or her interrogation. The interrogation procedures mirror the procedures afforded under what's called Weingarten rights and are applicable to all union members, both under the Myers-Milius-Brown Act and under the NLRB. The Peace Officers Bill of Rights and the Firefighter Bill of Rights largely just codify these Weingarten rights with respect to what happens at the interrogation. It gives basic requirements that officers have a right to a representative, they have a right to record the interrogation, they have a right to use the restroom. The notice is also similar under Kobar and Weingarten. Any public employee and officers are entitled to notice of the nature of the allegations. This is very limited information. Our Supreme Court has held that officers do not have a right of access to any of the investigation information. It's merely things like you're charged with excessive force from this particular date or this particular case. And it's intended to give them notice so that they can discuss the matter with their representative. Another important factor is that officers do not have a right to refuse to participate. They can be compelled even when criminal jeopardy attaches to the allegations. Once the investigation is completed, the agency renders findings. These are typically either frivolous, exonerated, unfounded, not sustained, or sustained. If it's sustained, then a corrective or disciplinary action is proposed. If it's any of the other findings, then obviously no action is taken. The 5th and 14th Amendments to the Constitution provide all public employees in California a property interest in their continued employment and a due process right to appeal any deprivation of that property interest. The Peace Officers Bill of Rights delegates the authority to the employing agency to establish what that administrative appeal procedure is. For the state, it's mostly the State Personnel Board. On the local level, as you might imagine, the process varies greatly. Most have some form of a civil service commission or a civil service board. that often employ hearing officers or arbitrators to make advisory decisions. Some agencies have arbitration. Under another Supreme Court case, Skelly versus State Personnel Board, public employees have a right to respond prior to the imposition of discipline to any proposed action of a 5-day suspension or greater. They have a right to a copy of the investigation at this point because the investigation is complete. And then after this Skelly hearing, which is really typically a meeting, like a settlement conference, they have a right to an evidentiary hearing. This evidentiary or administrative hearing is necessary to determine disputed facts and render legal determinations based upon the factual findings. If charges are sustained, great deference is given to the agency penalty determination, and the focus is on the harm to the public and the likelihood of reoccurrence. The final appeal is to Superior Court. I've heard complaints that it's nearly impossible to fire bad officers. That's simply untrue, but hopefully the increased transparency already enacted will better inform the public. Sustained serious misconduct nearly always results in termination. In fact, published case law holds that it's an abuse of discretion to reinstate an officer with sustained serious misconduct. In Colander, the court explained that the job is a position of trust and the public has a right to the highest standard of behavior from those they invest with the power and authority of a law enforcement officer. Honesty, credibility, and temperament are crucial to the proper performance of an officer's duty, and the court concluded that dishonesty is incompatible with the public trust. In terms of the biggest obstacle to weeding out bad officers, we believe it's the lack of a decertification process to prevent an officer who engaged in serious misconduct from obtaining employment as a peace officer in another agency. This problem is exacerbated when officers resign prior to the completion of an investigation into serious misconduct because the former agency will often simply close the investigation without completing it. We support a system wherein agencies are required to complete investigations of serious misconduct, regardless of whether the officer resigned before its conclusion, where the agency determination is reported to post, to make determinations regarding whether or not certification should be revoked. And as a matter of due process and thoroughness, we believe that any decision on decertification should be deferred until after the administrative appeal is completed. Thus, post has a complete record to consider at the revocation step, and we avoid double jeopardy and inconsistent factual and legal determinations. I know my time is about up. I welcome any questions during the question and answer session regarding the interplay between the discipline process and the decertification. Thank you.
Thank you very much, Mr. Mastagni. We appreciate your testimony here today and also representing public safety unions. We thank you for your perspective. Deborah Ramirez?
Yes.
Thank you so very much for being patient. The law professor at Northeastern University, thank you once again. You have 6 to 8 minutes, so please incorporate your introduction within that time, and you are up to bat. Thank you very much.
Thank you very much for having me during these important hearings. My name is Deborah Ramirez, and I'm a professor at Northeastern University School of Law here in Boston. The title of this presentation is, Why is it so hard to hold police accountable for risky behavior? First of all, I want to check sound. Can people hear me?
We can hear you and see you, yes.
Perfect.
Thank you.
When I talk to my students, I say that the answer is an answer that's been given already today, which is that we don't have any way right now to weed out the bad officers so that the good officers can thrive. Contrary to some of the speakers, my experience, the empirical data, and all of the studies indicate that it is almost impossible to lay off or fire a police officer because of union protections. And there's another reason for this lack of accountability. It's that even when you or I or someone injured by the police uses the court system and files a lawsuit, the officer does not bear the costs of any damages assessed. Now, I want to explain that for a minute. The courts and municipalities hold officers liable for misconduct, either by settlement or by verdict. Now, you might think that as a result, the officers would pay damages to the victims who they injured. But in fact, the officers pay not one penny. When you or I are sued for negligence, we have to pay the damages, but they do not, because they have negotiated with the municipalities so that the municipalities pay 100% of the costs of police misconduct. Finally, I think one reason that we've had so much difficulty holding officers accountable is this. We focus a lot of our attention on responding to shootings, responding to injuries, responding to acute, reckless acts of policing. But we are much less focused on preventing these acts from occurring in the first place by intervening at a much earlier stage. So my presentation, if you want to think about it in terms of one word, is prevention. How do we prevent the videos that all of us have seen from recurring? When I talk to police chiefs about this issue, here's what they tell me. They say, Debbie, I'm not in charge of the police. The police unions are in charge. They say, I can't hire the officers, I can't promote them, I can't discipline them, and I can't fire them. So I asked them, please explain this. I don't understand. And they said, we can't hire the people we think would be guardians of our community and problem solvers, because we have to hire the person who got the highest civil service exam test score. We can't promote the people who did an outstanding job of community policing because we have to hire the person who got the highest test on the civil service exam. And we cannot discipline the officers who we see with drug problems, alcohol problems, anger management problems, people engaging in risky behavior, people who were arrested for assaulting someone in a bar or arrested for drunk driving and convicted of it. We can't discipline them because of the labor arbitration system. What they say is that 2/3 of the time, their decision to discipline is overturned by the labor arbitrators, and that this is a system controlled by the police unions. And for all of these reasons, they also can't fire a police officer. Now, when I was thinking about what I would say to you today, one quote came to mind. It's short. It says, we can't solve problems by using the same kind of thinking we used when we created them. We need new ideas. We need an independent agency to develop a risk assessment and accountability system. And my solution is this. Why can't we insure police officers like other professionals and require them to carry mandatory professional liability insurance? Now, my neighbor is a doctor, and he said he has to carry professional liability insurance. And he said, if I started drinking or using drugs, operating on the wrong leg or arm, my insurance premiums would go up. And if I continued to do that, they'd go up more, and I'd be priced out of medicine. He said, I don't understand why police officers with dangerous histories and indicators aren't priced out of policing the same way by premiums that reflect the actual risk of their dangerous policing. The system that I envision would be a prevention system. Early on, the insurance companies, through risk assessment scorecards, would identify officers engaged in risky behavior. And they would say, look, you were just convicted of assaulting someone in a bar. You were just convicted of drunk driving. You have a domestic violence restraining order. You can either get treatment and training, or your premiums will go up. If you get treatment or training, your premiums go down. In this way, we would create an accountability system that dealt with some of these issues early on. How would it work? Well, an officer would have to carry professional liability insurance. And that's where you come in, because the state legislature could mandate that in order to police in California, every officer must carry professional liability insurance. The police department would pay the average base premium for all officers, so it would cost the officers nothing, but any increases due to risky behavior are paid by the officer. And the municipalities would be prohibited from paying for the costs of police misconduct. That would be paid by the officer and their insurance policy. What do the insurance companies do here? They do what they do best. They assess risk. They create risk assessment scorecards for the officers and find out and identify what everyone already knows, who are the bad apples. They are an independent agency. They assess risk in other areas. They price out bad drivers. They price out bad lawyers. They price out bad doctors. We're asking them to price out bad police officers. Now, if this system had been in place, lives would have been saved. An officer like Daniel Pantaleo, who strangled Eric Gardner in New York, would have been identified as among the top 2% of New York police officers with the most sustained civilian complaints, would have been identified as having 2 prior lawsuits and settlements and 1 prior disciplinary action. And he would have been priced out of policing before he met Eric Garner. The same would be true of Derek Chauvin, who strangled George Floyd. So what are we asking you, the legislators, to do? 3 things. 3. 1, limit the scope of collective bargaining for police unions as a matter of public policy. Prohibit them from bargaining about hiring, discipline, termination, and the allocation of the cost of police misconduct. Narrow the scope. You can do that, and as a matter of public policy, we should. 2, prohibit all municipalities in California from continuing to use taxpayer dollars to pay 100% of the costs for police misconduct suits, and by the way, for the legal costs for the lawyers who are testifying today. 3, require police to carry mandatory professional liability insurance like other professionals, and state that they may not police in California without that insurance. Thank you.
Thank you very much, Professor Ramirez. We appreciate your testimony.
Mr. Mastagni, are you going to go first on that? Go ahead, please.
Thank you for the opportunity to respond. Well, I generally favor outside of the box thinking. I think that this idea is ill-advised and fatally flawed for a number of reasons, starting with that California values include unions, collective bargaining rights, civil service rules so that we have merit-based hiring, not cronyism that's been for over 100 years, and that you have fairness and root out discrimination and open public employment to everyone. And another California value, and this has been recognized by the courts and in a number of statutes, is that employees should be indemnified by their employers, both in the private sector and in the public sector. And receive a defense. And if you look at Labor Code 2802, there's a general right of indemnity that applies to all employees in California. There are government code sections that are specific to public employees that refine those and deal with the government code section 995 and 825 that deal with the right to be defended and indemnified. And those are very important from a public policy standpoint, because we have to also think about the situations in California where any critical incident, an officer is going to get sued. That's just the fact, regardless of whether or not the officer's actions were justified or appropriate. And because of joint and several liability, the public entity is the deep pocket, and the public entity is the one that the plaintiff's lawyers are going to be primarily seeking compensation from. And so if you create a split where a public employer might, for good economic reasons, decide, hey, I can settle this case for $10,000 and that's cheaper than trying it, even though we would win, it would cost us $50,000. Well, if the officer is going to have to, these are working men and women making $40,000, $50,000 a year, go out of pocket for that expense, they're going to refuse to settle the case and force cases to trial. And so I think those adverse consequences need to be considered. I'm sure Mr. Touchstone has more insights on that, but I want to hit a couple of other things that I think are critically missing. Number one, law enforcement is not analogous to private sector professions. There are some public sector professions, you have doctors, and I represent a lot of public attorneys, and there are private sector attorneys and public sector attorneys, but law enforcement is unique. We ask these men and women to run towards the sound of the gunfire to protect us. And if you look at Professor Ramirez's proposal, or really any kind of insurance or actuarial assessment, it's not merit-based. These cases are too specific and unique. They look at statistical models that historically have been used to discriminate against people in terms of lending, housing, and employment. And they look at things, according to Mrs. Ramirez or Professor Ramirez's papers, it's how many times you've been sued. Has it been settled? It's not a determination as to whether or not the officer actually did something wrong. How many times have you had an internal affairs complaint against you? Have you been involved in a critical incident, including, by the way, even if the officer didn't use force and was just present? You look at the assignments that officers have, because you will create very perverse incentives where officers, in order to protect their job and their pension, will shy away from the work that we need them most to do, and that is to run to the sound of the gun and protect us, the citizens, when somebody is creating an imminent threat. And so if you're on a SWAT team, for instance, you're going to be involved in a disproportionate amount of critical incidents, probably over half of the critical incidents of your agency. You will instantly get priced out of being a peace officer under this model. If you're on a warrants team where you're going and arresting violent felons, you're much higher likelihood of having to defend yourself in a use of force situation or having a complaint made against you. And do we really as a society want to set up a system where officers are incentivized to try to get into training or investigations or desk work and avoid patrol, or that officers on patrol are scared to take proactive action that we ask them to do and we want them to do, and only respond to dispatched calls for service because they're scared that they will get priced out of this market? There's other constitutional problems, and respectfully, California is not like Boston and some of these other states. We have a home rule here which prohibits the state from setting compensation for local employees. And so as my understanding of this proposal would be that local entities would be mandated to insure a base level of insurance, which is an interference in municipal affairs because many agencies choose to self-insure, and then would be prohibited from agreeing to a compensation package that would cover the cost of the indemnification. And so the effect would be, we would be singling out a specific class of employees and say the rules that apply to every other employee in California do not apply to the men and women who put their lives on the line to protect us. And we would be creating these incentives that I think are contrary to public policy. When you look at, as Mr. Lackey said, other professions like doctors and lawyers, they have time. and they have tranquility to make judgments. They also don't have to buy individual insurance. That's a misnomer unless you're a solo practitioner. Every attorney at my office is insured by the business for their malpractice. The same is true of medical groups, public attorneys, public doctors. And so from just a fundamental public policy standpoint, I believe strongly that we don't want to put in place incentives that make agencies and officers not want to run to the sound of the gunfire, not want to give us protection. And one final point is the Supreme Court and this body recognized, I think it was 1975 or 1979, with the statute called MICRA, that we were going to price doctors out of the market with malpractice insurance in California. And so the state imposed a hard cap of $250,000 in liability on doctors in order to stabilize the insurance market so that you don't have a flight of doctors from the state. And I would submit to this body that there is a very real risk. We already have a shortage of officers in the state, that this prescription, I think, would be far worse than the problem that it's trying to solve.
Just one comment, if I may, Mr. Mastagni. You said that employees would be indemnified, and that's a right they have. However, if an employee, and correct me if I'm wrong, if an employee is found guilty of criminal conduct, the rules are not the same. If they did an intentional criminal act, then they can be held personally responsible. But in all other instances, I would agree with you that an employee, being an employee of the city, of the municipality, would have that protection. But I
address that point, and thank you for pointing that out. I did omit that the indemnification is limited to course and scope. And so if an officer commits a crime, that's not within the course and scope of their employment. They're not indemnified, nor should they be. And the same is true of punitive damages, where there's an intentional violation of someone's constitutional rights. But in the routine day-to-day employment, I send you to the shots fired call, and you appropriately defend yourself or defend a member of the public. For sure, you're getting sued in California. And so an insurance broker looking at that is going to say, well, you're on the SWAT team, you're going to be responding to calls. That means you're going to get sued. I don't care whether or not you did anything wrong. I just care that your liability is going to go up, and I'm going to have to defend more lawsuits because of this assignment that you took. And so you're priced out of the profession.
I think those are really important points. And I think that if this is pursued, as has been noted by some of my colleagues, I think your voice is important. You certainly do a great job of defending the rights of our officers. Your comments are very well taken, and that voice needs to be heard if this is something we would be interested in implementing, because it seems that other ideas haven't really worked, and that we've got to find those novel ideas. As you said, we have to look outside of the box. But thank you for those comments. Thank you.